What's the problem? Huh? So we are starting now. They're calling it out. I don't know that they are not ready. They'll never be ready. They'll never be ready. Sleep room. Giving it to this idea, man. Finish. I'm gonna take photos. We'll highlight it, but we have better points to argue. James Mwangi. That chick, how old she is? Oh. Dennis Maina. Justus Musua. Victor Kinyanyui. Raymond Mushigi. Vile Nyambura WhatsApp. Michael Kadari. Maina Kariuki. David Mwangi.
David 1. John Nana. John Nana. Esther Wanjiku. Mercy Wanjoy. Eric Mwanja. Eric Mwanja. Mwaniki, sorry, Eric Mwaniki. Daniel Sidari. John Karanja. John Karanja. John Karanja. David Yanga. David Yanga.
Kuna demo nyingine hapo amekaa mtu yeye anaitwa Masi uulize age. Yeah. That's how they do. That is nice. That is what we want. That is I'm for him. I am for you. You confident.
Moses Mwan. John Opio Ougo. Rogas Green. Francis Mwan. Edmond Michel. Simon Kamau. Simon Jum.
On John, on the client.
Eliud Mwan. Felix Otieno. Brian Yoko. Lucas Mogo. Sean Juma. Brad Monen. Peter Juma. Samuel Ndegwa. Joseph Kamau. Joseph Njeri Ngoni. Michael Maura Wainaina alias Michael Dulu. Brian Juma Wainaina alias Joseph Langatu. Samson Maura. Tom Mwini. Brian Karanja.
We'll take more time arguing that.
Francis Jukuna.
Let's just argue it. Sleep, bro.
Peter.
So yeah, it's fine, but I don't want. But we are John based on that. Good afternoon, Your Honor. If it may please you, in the matter of Mr. Abner Mango, kindly place me on record for the suspects, for the 58 suspects. Your Honor, I do appear alongside Mr. Babu Owino, Ms. Wajira Maina, Mr. James Ongoma, Mr. Nurdin Kagai, President, and Mr. Kelvin Michuki. Your Honor, the matter is coming up under miscellaneous application. We are ready to proceed.
Your Honor, the matter is to order for the state. I appear alongside Ms. Odisiko. And Ms. Ngo. This application is hinged on Article 49 GHN, and the state is seeking for the continued detention of the suspects for a period of 10 days. The investigating officer who is before the court, Inspector Bondo.
The respondents, after they were arrested, the offense which they committed was within Jinja sub-county, which involved destruction of property, looting, forced entry to Thika police station, threat to safety, order and national security. Your Honor, when the suspects, before they were arrested, they invaded Thika police station. That was around 13:00 hours when they started howling stones and all kinds of projectiles to police officers who were manning Jinja police station. This continued for almost the whole day until in the evening at around 6 when they were reversed by police officers. And during the time they were being reversed, they as well damaged police vehicles, two police vehicles, that is GK B792W and GK B837V Land Cruiser, which they shattered their windscreens. Then after being reversed, they all went in different directions, and most of them, who were numbering around 1,500, managed to enter into Malay supermarket, which they broke the doors, and as well, they injured the workers who had already locked themselves inside the supermarkets. The supermarket is about 400 meters from the station. When we received alert, police officers rushed to the scene and managed to arrest the 58 having robbed, jointly with others who managed to escape. The employees and members of the park.
Perhaps just for the sake of the court getting the proper picture, you have indicated to court that these respondents attacked the police station at about 1300 hours. what time were they allegedly at Madai's supermarket, and what time were they arrested, and how were they arrested?
They were arrested at around 20:00 hours. And how they don't fear police officers. They also claim that they can also fight back and they are ready to be defended.
Objection, Your Honor. That line of submission in the application is not grounded in the application. It's submitting from the dock. We have not seen any such submissions in the face of the application.
I was a eyewitness, and I will also testify before court.
Then if he's willing to be cross-examined, then very well, we'll take that line.
So, Your Honor, I have compelling reasons as to why they should be detained, because none of them we have known is abroad. His place of residence. And for these offenses are so serious, we need more time to investigate thoroughly so that we may prepare the charges, record statements from various witnesses who have not yet turned up but have reported to the station. We also need to get an audit report from Madai's supermarket for the items and goods which were looted.
Are you talking of audit or inventory?
Inventory plus audit of items.
So, Inspector, it is your assertion that these suspects were arrested inside the supermarket?
That is true.
Terrible juice. Terrible juice.
Now, this supermarket being a private property, does it have any CCTV footage or any such?
Yes.
If you have questions, we cannot cross-examine somebody. What do we do?
Is that all, or there is something else that you wish to add?
That's all.
Then just for purposes of good order and submitting of record, I just want to get clarification whether my colleagues wish to cross-examine you, and then we submit.
Yes, yes.
And then they cross.
No, we cross-examine.
It's part of cross-examination. It's part of cross-examination.
Good afternoon, Mr.
Bondo.
Mr. Jarius Bondo. Yes, I'll ask you a few questions. I hope you have the application with you. What are the orders that you seek in your application, the instant application?
I'm seeking for the suspect to be retained at the police station for 10 days.
I want you to have a look at order number 2 as framed. Is in that order ambiguous from the framing of the said order? Order number 2 on your application. It's the same application you have. So what are you asking this honorable court from the face of order number 2?
Retain the suspect.
Where?
The police station.
No, read your application. I draw you to the last sentence. Where exactly do you seek to detain the suspect?
Be detained at the police station.
for 10 days from today at Juja police station. So where exactly?
It is within Juja. That is
So you are not sure? You are not even sure. Thank you. So on to the second question. On to the second question. You are part of the investigating officers in this matter?
Yes.
Did you take time to ascertain the age of the 58 respondents?
Yes, I did.
Can you affirm to this court whether or not they are all of majority age?
All of them, there is none who is under 19 years.
I wish to draw your attention to the 24th respondent. Mercy Wanjoy, the 24th respondent. Mercy Wanjoy. Did you take time to ascertain the age of the 24th?
She is 19 years old.
Did you take time to ascertain this being as an investigating officer?
That is the reason why
An officer of the court.
Requesting for more time to investigate.
Investigate or ascertain the age.
I will ascertain when I'm investigating.
So you're doing things the wrong way. So I wish to draw you to the contents of paragraph 5 on the grounds in support. You allude to widespread destruction, looting of property, and forcible entry into the station. Have you provided in your supporting affidavit any annexure in support of the same?
We have photographs.
Have you annexed as you stand on the dock?
I will provide them the moment I will be testifying before court after.
So your government under paragraph 5 is premature.
I am requesting time from God and investigate for that and will bring footage.
I will step it up and draw you to paragraph 6, where you say that you have recovered exhibits to mean that they are within your record or custody. True or false?
Yes.
So have you presented before this court any photographs, any inventory of things that you have recovered as exhibits?
I will provide them when.
So you will, futuristic. Sorry?
After investigation,
So at the time of drawing and filing this application, paragraph number 6 is an averment, is a mere allegation. You cannot prove it, that you have the exhibits.
I have this.
Where are they?
They are the station.
What are they doing there? Yet you have said you have provided exhibits.
This is not, we are not, this is an application of making.
Now, you have averred that due to the activities of Saba Saba, there were reported injuries. True or false?
Yes.
To the police officers?
Yes.
So, is there any medical report that you have presented before this court to ascertain the nature?
Even they are going to be given with reports.
Have you annexed any? From where we stand, can we ascertain the number, nature of injuries?
They have recorded their names in the occurrence book.
My questions are yes or no. Have you annexed any medical reports
Yet
in your application? You have.
Yet
Please draw me to.
annexed.
Yes?
Yes.
You have annexed.
It will be annexed.
So you have
By
not.
the time I will be testified.
Thank you.
This is not.
You have alluded while answering to OB reports. Have you provided the OB report numbers?
Okay, it's 29 of.
No, that is for the arrests. I'm asking for the injuries. You've said they are OBs. Have you provided those OB numbers?
I'm yet to record the statements.
So you are yet to do anything,
Yes.
rather than arrest. So you have not done
Yeah,
zero
I haven't done
investigations.
anything so far.
You have done nothing so far. Thank you. You want to leave it at that? I'll leave it to my colleague.
Mr. Mbondo,
Yes.
I'll just pick it up from where he left. So you have said that you are here to do investigations.
I'm here to request time to finalize my investigation.
So if you're here to do investigations, why are they arrested?
Because you were arrested on the spot.
What follows? Investigation or arrest? What starts? Do you arrest someone, then investigate, or do you investigate and arrest?
They were demonstrating,
Ah,
and immediately after that, they went to commit an offense.
committed an offense. That is what you're saying. You have talked about an OB number 29/07/2025, right? Is that OB anywhere in your affidavit? Because that's just a number. Have you shared the same with the court? Do you have a copy of that complaint?
When you request it, we shall bring it.
What follows? What follows? You swear something without an extra?
The OB is there. It is written.
So we can't rely on that number
You
because we can't.
can, because it is there. When
Please.
you request it, if it is requested by court, and provide.
How do we know that OB is not about a stolen chicken?
That is your assumption. It is
No, it's
there.
not an assumption.
It is there.
Anyway, you talk about 1,500 people, right?
Yes.
How did you know the 1,500? Your number, not mine. How do you know the 1,500?
I know how to.
Do you have a list of? Do you have a list
I know how
of
to
them?
estimate. You know
Oh,
how to
estimation.
estimate. It was my
You
estimation.
wanna help you right? So you estimate
It was my estimation.
ulipima na macho.
It's my estimation.
So since you have 1,500 people, do you have a list of them 1,500 people? Because that is a number. For you to come up with a number, you have to have a list of names, right? So you're saying these are part of the 1,500, according to you.
Yes, yes,
Is there evidence to show that there were 1,500?
yes.
Where is the evidence?
The footage.
Point me to the evidence.
Footage will state it.
Or the footage counts, eh?
Yes.
1,500. We're waiting for the footage. Secondly, you talk about a vehicle, two vehicles, GKB 79-2W and GK 83-7V, Land Cruisers, right? You said they threw stones which destroyed the vehicles, the mirror, right?
Yes.
So all of these people, you collected one stone and stoned the entire vehicle. Because you're saying respondents, meaning all 58 of them. No, it is your statement. I'm reading your
It is
statement.
them. They were jointly with others.
So all of them threw a
Even
stone.
others have not been arrested.
Have you showed the court how they hit that car or those cars?
I will provide the photograph.
You will provide. So it is you telling us what you will do. Okay. How many people can carry one stone? By the
You can carry even 10 stones.
I'm saying how many people can carry one stone? According to you, after they were dispersed, you're just from telling us they moved in different directions. Let me point you to number 9. Read for the court. That the respondents, upon being dispersed, then proceeded to Madai supermarket. So which is which? Different directions or Madai supermarket?
Those who were arrested proceeded to Madai supermarket.
No. You have said.
Those who were never arrested, they
No.
never proceeded.
Don't be clever. You have said once they were dispersed, they moved in different directions. So my question is, what is Madai different directions? Because now
Madai is one of the directions.
you said once they moved to different directions. Your statement, not mine.
They moved to different directions.
So you don't
but
know what
the ones
you
who
are-
were arrested moved to Madai.
You are not sure. Very well. So another question. You have talked about that they began looting and robbing customers. Is there any customer that is a complainant in this case?
Yes,
Have you recorded a statement?
that is what I'm.
Oh, you are still doing that, but they are arrested. Very well. You talk about number 13. You are doing forensic. You want to do forensic evidence, right? Because you have experts.
Yes.
My question to you is one: have you collected any gadgets from them? Their phones, laptops,
Yes, I have.
their phones.
Yes.
Where is the inventory of the same? Is it in court?
I have it.
Where is it? That is my question.
I can't attach it to an affidavit.
Where is it? Does the court have the same?
I will provide it.
Who said you can attach it? Supposed to attach.
The time has not come.
Who says the time has not come? Any letter to DCI? To conduct the forensics? You got a letter to DCI?
Yes.
You have written. Where's the letter?
Cannot be attached to an affidavit.
Why? How do we know you're doing the forensics?
That is part of my investigations, and that is why I'm.
And this is part of my work I'm asking you. This is because if anyone loses a phone, how do you follow up? Without an inventory, without a letter to DCI. As I finish, you talk about there are flight risks, right?
Yes.
Have you showed the court how or why there are flight risks? And before that, has anyone here before court ever been charged with an offense? Do you have a record of any of them? Do they have previous records?
Yes, take their fingerprints.
So you don't know, but according to their flight risks, you have judged them through your eyes. No further questions, Your Honor.
Here are just two questions to the suspect.
You are who for the record?
Mishuki. Yes, Inspector.
Yes.
I'll just ask you two questions. They're simple. You have placed before this court your affidavit, in which you say you are the investigating officer. You did not arrest any of these people.
No.
No, you did not. And you made allegations about where they were arrested, where they were rounded up. Do you have an affidavit of any of the arresting officers to attest to that?
I have their statements.
I'm asking, do you have an affidavit
I
before?
have their statements.
Are those statements annexed to your affidavit?
They cannot be annexed.
It's a simple yes or no. Are they annexed or are
They are not.
They are not. Thank you. We move on. A distance of, let's say, 500 meters from your evidence, yes?
400 meters.
400 meters, even less. 400 meters. So all your witnesses and all the evidence you're collecting is within these 500 meters. Yes?
No.
Physical evidence is within these 500 meters? Okay. Where is this other evidence if it's not within these 500 meters?
That one I cannot disclose.
Which leads me to the question. Since the 7th of July, what evidence have you collected?
It is only one night, so I could not.
Today is the night.
More evidence as I require. That is the reason why I've come here.
Have you collected anything?
I have evidence. I have evidence.
Have you annexed them? Have you referred to them?
After that, I have evidence which I will have.
Unknown,
They are
innumerable.
They are known.
Lastly, the last two questions. You say that you need time to collect the CCTV from Madai supermarket and to do the audit report come inventory. Yes? That is the remaining part of the investigation.
No.
But this is the one you highlighted to the court.
Yes.
So, these 53 suspects, can they in any way, have you indicated that affidavit, in any way interfere with your collection of that CCTV, audit report, or inventory?
Yes, I have indicated.
Where? Show me the paragraph.
In my affidavit, I've stated that it is in the interest of justice and fairness that the Honorable Court grants the custodial orders so to enable the applicants to conclude investigations without interference or obstruction.
You are saying? So do you disclose in what way they will interfere or obstruct the investigation?
They can interfere in many.
Have you indicated in your affidavit? Don't speculate. Inspector, just say, have you indicated it in your affidavit? If not,
They can interfere with witnesses.
tumaliza hii maneno.
They can interfere with witnesses before.
Have you indicated that in your affidavit?
Interference means that.
Lastly, Mr. Inspector, with regards to this person having no known abodes, yes? You have seen that. You've indicated the names of these people. Where did you get this information? You've indicated first to 59 to 58 are Victor Munyao, Sirisia, and the others. You've indicated their names, yes? Where did you get this information?
About what?
About their names. Where did you get their names?
They gave me the name.
They gave you their names. And you saw the identification, I am sure, to confirm those were their names.
So far noted, I will confirm. That is the reason why.
You did not take the IDs,
I have not taken their fingerprints. That is what I'm saying.
but you take the IDs to confirm their names.
Somebody can collect ID from the streets.
What you did, just
I-
there is a yes or no.
Their fingerprints will tell me their names.
I do not want to stop putting the catch in front of them. Okay, just answer. Did you take the IDs to confirm their names?
Most of them had no IDs.
Okay, but the ones you did, you took the IDs?
Yes, I do.
At the back of that ID, it's indicated where these people come from. Is it not?
Most of them do not have ID cards.
No, the ones you took, is it indicated where they
It
come
is
from?
indicated. ID cards are indicated where people.
So you are therefore giving false information when you say you don't know their phone. Is it not true? It tells you even their location, sub-location.
That is your assumption.
That is what's taking place.
Your Honor, that's all in cross-exam.
Inspector, do you have information of where exactly these suspects reside?
No, yeah.
Repeat the question for the record.
I repeat for the sake of the court, do you have information of exactly where the suspects who are before court reside? Not where they live, or where they reside?
I don't know.
Do you have any information whatsoever of what they do for their living and where they work?
No, Your Honor.
Have you completed your investigations on their age and their exact and correct names?
No, Your Honor.
That's all the from the witness. Your Honor, the submission. Is that under Article 49(1)(g), the Constitution foresees three possibilities in as far as an arrested person is concerned. The first possibility is where they are charged. The second possibility is where reasons are given for the continued detention. And the third possibility is where a suspect is released on reasonable bond terms or such as other conditions are as necessary to the court. In the celebrated case of Oscar Sudi, which I am sure has been quoted before this court. Justice Joel Ngugi stated that whereas it is undesirable for the freedoms and liberties of citizens to be curtailed by the state, where exceptional circumstances exist, which form the bedrock of compelling reasons why a suspect or suspects in this case should continue to be detained without being formally charged. The learned judge will find that such orders should be granted once it is established that the state is acting in good faith and that the three-pronged interest that is the interest, public interest, public order and security. The interest to uphold the sanctity of the administration of justice, and also during the events of the 7th day of July this year, as such that there was massive looting and destruction of property in other parts of the country. It is therefore our prayer that since the suspects were arrested allegedly in the course of committing the offense of looting within a supermarket, after allegedly committing other offenses in the course of the day, Your Honor, those circumstances were so exceptional that it was impossible for police officers to watch these offenses being committed and allow the offenders to walk away, to allow for investigations and arrest later on. In practice, investigating officers arrest after investigations. But the gravity of the offenses and the manner in which these offenses were being committed on the material date necessitated that the suspects be arrested immediately, presented before court, and investigations to follow thereafter. Well, in conclusion, it is therefore our prayer that whereas several of our precedents and jurisprudence in the country does not take pre-charge detention, this is a unique circumstance. That calls for the court to grant the state the bare support.
It's easier. Maybe I'm just doing preliminary.
To ensure that the right to property, the sanctity of life, and the need to preserve the integrity of the administration of justice is upheld. We therefore pray for the suspects to be detained as claimed by the investigating officer. Thank you.
Counsel, you had said you are cross-examining without any submissions.
If the record captured that way, then
Yes, that is what
I did not assert that.
are you calling?
We have to if the record captures that, then we can
Yes,
strike
we
it out
shall
of the
go
record.
there.
We have to
When,
strike that out.
when counsel said
The IO.
yes,
Yes,
during
I was
the
opposed
IO's
to the line
cross-exam,
of him submitting on grounds that
she
were not.
asked you whether you were going to submit or cross-examine.
Your Honor, if my memory serves me right, when he made allegations on factual issues that were not on the ground.
Instead of all this, which is a considerable consumption of time, yes, you can clarify then.
Oh, very well.
I wanted a clarification on whether the council should be allowed to first cross-examine and then later on submit, or we should submit first and then later on cross-examine. So his right to submission was not.
Okay, but let it not take 20 minutes of the court's time.
Your Honor,
Briefly.
I'll take 5. I think we'll allocate each other 5 minutes, so that will come to 30 minutes. Very well, Your Honor.
No, not 30 minutes, the court's time, not your time. We have other accused persons waiting for justice.
Very well. Your Honor, I'd refer this court to Article 21(1) of the Constitution, which gives this honorable court the fundamental duty of the state and every organ to observe, respect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. So all actors, be it the court, be it the ODPP under Article 157, and even advocates under Section 456 of the Law Society of Kenya Act, we are enshrined or enjoined by the Constitution to act in that manner. Your Honor, it is unfortunate that the proceedings and the application before you has been brought under circumstances which I'll shortly demonstrate that are in clear violation of fundamental rights and freedom of the suspects. Very important and preliminary, Your Honor, is the provision under Article 49(1)(f), which provides an arrested person the right to be presented before a court as soon as reasonable, but not later than, Your Honor, 24 hours after being arrested. Your Honor, the prosecution has craftily averred that they placed the suspects in their custody at around 2000 hours on 7. Your Honor, even if we were to go by their submissions, which we oppose and strongly deny, because most of these suspects were arrested way before that time and have spent more than 36 hours behind custody. Your Honor, that article enjoins not 24 after 24 hours. It is within 24 hours. And they have not endeavored absolutely to give any reason whatsoever or any circumstances that would have prompted for them to invoke Article 49(1)(f)(2). That is why they should have, why they brought them after the 24 hours. So that is a clear violation. Your Honor, that is important for us by dint of Article 25A of the Constitution, which provides for human dignity. Your Honor, we can argue all we want, but one of the fundamental freedoms, Your Honor, is the right to be treated in a humane way, not in a degrading manner, and not to be punished. Your Honor, most of the suspects here in contravention of the same have been inhumanly treated. They have been punished. Some of them are limping. Some of them are injured. And Your Honor, very unfortunately, they are malnourished and famished. They have not eaten. Your Honor, in fact, with the indulgence of the court, we will be seeking, because we have well-wishers who brought some bread and milk, if they could be served with the same, Your Honor. From the face, you could see. Your Honor, Article 43(2) also provides for the right of any person to be accorded medical treatment. Your Honor, some of the suspects before you have been injured. Some of them, their eyes are red because of the injuries. They have bloodshot eyes, which indeed needs immediate emergency medical treatment. And as such, none has been accorded within the 24 hours, after the 24 hours, and they are better off at their homes, where they can now personally secure and guarantee their rights. Your Honor, 2 points before I conclude. The application before you, my colleagues will clearly demonstrate, is a frivolous application. Your Honor, the DPP is entrusted under Article 157(11) to act in a manner that promotes public interest. Further, Your Honor, Section 4 of the ODPP Act, the DPP should act in a manner that promotes public confidence. The manner in which the arrests have been conducted, the treatment of the suspect while in custody, their continuous detention without trial, does not in any way promote public interest or instill public confidence in the prosecution. Your Honor, we are saddened that the IO who has taken the dog did not even take time to ascertain the age of these suspects. Your Honor, Section 8 of the Children's Act enjoins each party to act in a manner that promotes the best interest of children. So even seeking 10 days to continue holding a child who has parents reveals and clearly shows the malice behind this application, the misuse of custodial applications, which will be extrapolated by my colleague, And Your Honor, we will be urging you in our submission that for the case of the children, let them be released unconditionally to their parents. But for the rest of the suspects, Your Honor, let them be released unconditionally or on personal bonds. Your Honor, I'll invite Ms. Wanjira to proceed. Submission.
Good afternoon, Your Honor. For the record, my name is Wanjira. Your Honor, a lot has been said to you this afternoon, but it is important to note that the prosecution has conveniently omitted the fact that there is no holding charge to continue holding the respondents. The application, you have been told, is premised on Article 49, 1 specifically F, G, and H, I believe. To quote Justice Kimaru in Michael Rotich versus the Republic, the citation, which is 2016 EKLR, Justice Kimaru came to the conclusion that the proper and constitutional meaning of being informed for detention continuing as you're being sought by the prosecution, the proper constitutional meaning of that phrase and of Article 49 is for there to be presented a holding charge. The only thing you have been brought, or the only thing you have been presented to, Your Honor, is just a narrative based solely on the word of the inspector that there are offenses correctly known and contemplated in law, but these do not amount to holding charges. In the alternative, Your Honor, you have been told that there are compelling reasons to continue holding them. So there is no holding charge, but there are compelling reasons. In regards to the compelling reason, Your Honor, it takes us to Section 36 again, on which this application is premised. When looking at compelling circumstances, Your Honor, you should be looking at the nature of the offense, the general nature of the evidence tabled before you, the inquiries that have been made by the police, and the reasons that necessitate the continued holding of the respondents. I think everybody here has heard the police inspector speak in a futuristic sense. I will record, I will present, I will annex, I will disclose, I will attach, I will audit. But he has brought you nothing. Your Honor, he has not presented you with names of complainants. He has not presented you with OB numbers. He has not presented you with photographs of allegedly damaged vehicles. He has brought you nothing. Your Honor, the only compelling material you have been tabled or you have been presented with is just the word of the inspector, nothing else. This obviously, speaking from his hollow affidavit, just the strength of his word, nothing else. You are supposed to waive this respondent's right to liberty and presumption of innocence, just his word alone. A question has been posited, I think, by the prosecution, whether the inspector knows where the respondents live. And because the inspector has done absolutely nothing by way of investigations, then the respondents cannot be released. But that is not the legislative path that has been set before you, Your Honor, under Section 36 of the CPC, again, that premises, or that, that this application is premised on. In considering whether to release the respondents, Section 36A, subsection 4, obliges this court to look at three things and three things only. Number one, the need to safeguard investigations by ensuring non-interference of witnesses. As we speak, Your Honor, You have not been given any names of witnesses. You have not been given copies of their complaints. You have not been given OBs. You have not been given anything. Therefore, it is logical, and I would say maybe even common sense, to conclude that there are no complainants at this stage, because none of the names have been brought before you. It is said that the respondents were looting and even beating the people that work at Mathai Supermarket. You have not been given any names of injured persons that work at Mathai Supermarket. So even if they were to come on as witnesses for the prosecution and even for the investigator, those names have not been brought before you. So there are no witnesses to be interfered with at this moment, Your Honor.
Just summarize here.
In closing, two other things need to be considered by this court: whether the respondents are available to facilitate investigations, and whether they can appear at the specified place that is named by this court. Your Honor, the respondents are able and willing to present themselves at Kibi or at Juja police station if the court obliges it. And therefore it should not be a reason that the fact that the inspector does not know where they live is not enough reason to prevent them from being released by this court today. My able co-counsels will demonstrate other things, but it is clear that this is simply a good example of police overreach and the weaponization of the criminal justice system against its respondents. Thank you, Your Honor.
Good afternoon, Your Honor.
Let's proceed.
Your Honor, on the notice of motion, paragraph 5, we are being told that the respondents resulted in widespread destruction of property. Widespread. Your Honor, you know that the standard of proof in any criminal matter should be proof beyond reasonable doubt and not proof on a balance of probability. And therefore, Your Honor, when we talk of widespread destruction of property, it means that the rule of specificity is not observed. Then they further go and tell you that there is looting of private property, and then they don't provide evidence to that, as at today, as at now. And they talk of that the respondents will pose a serious threat to public safety and national security. Your Honor, I will draw you to a case of R versus Richard David Aldens. That is the High Court at the High Court of Nairobi, criminal case number 48 of 2016, where the court denied a claim that an accused should be detained because the case was highly publicized, and therefore releasing the accused would cause a breach of peace and public order. Your Honor, the court held that the prosecution's claims were speculative and that it had not provided evidence demonstrating the unlikelihood of arrests. So therefore, Your Honor, in addition to that, there were no complaints made from the public. I draw you to your brother, Justice Wasame, as he then was, in R versus Munir Haron Ismail. That is criminal revision number 51 of 2009. And he said clearly, Your Honor, that the basic denominator is to secure attendance of the accused, in our case, the suspects, to answer to charges against him. Your Honor, in paragraph 6 of the notice of motion, we are told that during the arrests of the respondents, several items were recovered as exhibits. And Your Honor, clearly, they've not shown. We don't have the exhibits before you. We don't have an inventory before you. Even photographs, Your Honor, we don't have. So these are just mere statements of puff or mere averments. In paragraph 7, Your Honor, of the notice of motion, we are being told about the seriousness of the offense. Your Honor, that owing to the seriousness of the offenses, the risk to public security and national security implications. Your Honor, the suspects you are seeing before you, vis-a-vis the police, Your Honor, the state has monopoly of violence and has all the tools of violence. Your Honor, if you see in some of the videos on social media how the state, how the police is executing the young ladies, the future of this nation, and men, young ladies and men, Your Honor, your heart will bleed. And if they are doing that to the unarmed civilians, what about those who will go to the police station armed? They can bomb them, Your Honor. Paragraph 8 of the notice of motion, Your Honor, we are being told about the complexity of the investigations, and that this includes recording of witness statements. If I had my brother, the inspector, he stated clearly that the witnesses went to the station and at the same time he's yet to record their statements. And Your Honor, the suspects before you have been held beyond 24 hours from 7th to 9th. So therefore, Your Honor, when you look at the cases that are presented before you that they will be charged with, that robbery with violence, and you slightly go deeper into the elements of these charges, robbery with violence, you see, and he agreed that he did say that he found the suspects in flagrante delicto, red-handed. So that means that, Your Honor, if he was to carry out forensic analysis of what? If you look at the elements of that crime, which entails that they are found in a group, found with weapons, they must have been violent, and the element of robbery established. So you are being told that they need more time to carry out forensic analysis, Your Honor. Another case is the assault of a police officer, Your Honor, and we are not told of the OB number of the said case, not here as we speak, and at the same time, the names of these officers, not told. And Your Honor, we are also not told of any P3 form that has been filled. Then, Your Honor, as I finish, when I come to paragraph 6 of the affidavit, Your Honor, paragraph 5, sorry, that at the time of the arrest, the respondents were duly informed of the reasons of their arrest, which is good enough. And Your Honor, By the time you are being informed of the reason of your arrest, it means that the IO is ready to charge you. So which means that the investigation is complete and therefore charge. But it comes before you, Your Honor, persuade the court that I've arrested the suspects, give me more time. I've even held them beyond the 24-hour rule. I still need 10 more days so that I can continue investigating. By the time they were informing them, the natural laws of justice dictates that you arrest, you investigate, then you arrest. Not arrest, then investigate. Paragraph 6, Your Honor, I'm almost finishing. Paragraph 6, you are told that the respondents herein are believed to be part of a group of approximately 1,500 individuals. Believed to be part of a demonstration turned violent outside Juja police station. Your Honor, this is hearsay evidence, which is not and should not be admitted in this competent court. And Your Honor, the IO did not tell us that he's an expert in matters statistics or mathematics. That when he looks at a video, he knows that these are 1,500 people. Even myself, Your Honor, a certified actuary, having scored first-class honors, which is mathematics, pure mathematics. Your Honor, I cannot look at a video and say, these are even 40 people, leave alone 1,500. As I finish, Your Honor, paragraph 17 of the affidavit. You are being told, Your Honor, that the respondents pose a high flight risk. And I will draw you Your Honor, we are being told that the respondents are a high flight risk. And there is no evidence given. He just says that we do not know where they are coming from. Your Honor, they do not have to know where they come from or where they stay, so long as the respondents attend court religiously and spiritedly. And Your Honor, be that as it may, the respondents have identification documents which they can leave before you, Your Honor, where they can be found. And that can help you, can help the IO, to trace them. And Your Honor, these are not foreigners, these are Kenyans, law-abiding Kenyans who are enjoying their rights to demonstrate. Your Honor, you are also being told that the seriousness of the offenses, and that I will give you the case of Richard, again, R versus Richard David Alden. And it was stated clearly that even a capital offense does not constitute a compelling reason. Even a capital offense does not constitute a compelling reason. And in the case for flight risk, Your Honor, I just give you that case, I'm sorry. in Job Kenyanya Musini versus the Republic versus Job Kenyanya Musoni, High Court at Nairobi, criminal application number 399 of 2012. The court allowed a bail application and held that mere allegations that the accused was a flight risk did not suffice. The prosecution ought to have substantiated its claims. And there is no proof that they even have passports. So therefore, Your Honor, as I finish, the definition of compelling reason as per the Thesaurus and Oxford Dictionary is that it has to be something so grieving, so strong, so convincing, and so undeniable. Hence, Your Honor, Article 49(1)H states that an arrested person has a right to be released on bail or bond unless there are compelling reasons. Yet the reasons that were being given by the prosecution are uncompelling, frivolous, and fickle. Therefore, Your Honor, Article 37 protects the respondents to enjoy their right to peaceably demonstrate, picket, and present petitions. And further, Article 21, I don't know if you lost me, Your Honor.
That's summarized, Counsel.
Article 21 further states that it is a fundamental duty of state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. And therefore, the respondents should enjoy their right to liberty, which is enshrined in the Constitution, and not granting them the bail, Your Honor, is infringing on their right to liberty and may amount to miscarriage of justice. Rest my case.
Then I will be brief. Your Honor, it is our humble submissions that
You are?
not deemed, sorry,
You are?
not deemed. It is our humble submissions, Your Honor, that an affidavit is used to adduce credible, the word here is credible evidence. What you have before you are averments, for lack of a better word, narrations of how the IO sees things. We have not seen any annexes, any statements, any letter to the DCI, or anything, or a photo to show what exactly he is deponing. Your Honor, in the affidavit we are told that the respondents were arrested due to robbery with violence. I would like the court to take judicial notice of the fact that there is a present circulating video where the respondent, that is number 36 and 37, were seen rescuing a short man. And by short, I don't mean mfupi. I mean somebody was shot. And in the course of trying to rescue the person to offer first aid, where respondent number 37 is a certified first aid personnel with a certificate. They were arrested and Bangalakna police station. That is to show you that the affidavit is full of falsehoods and claims of robbery with violence, so as to try and attach the offenses on the said respondents. Your Honor, further, due to the lack of any exhibits, statements, and credible evidence, the affidavit before you cannot be used to charge the same without the depiction of what they try to show. The said respondents who we are told have no abode, there is nothing to prove that they have any previous records or that they are.
Just counsels
I am
for
finishing.
saving the
I am
court time.
finishing. I am
Don't
finishing.
cover ground
I am
previously
finishing.
covered by
This one has not been covered. You will see it. There is no mention of any of the respondents having been charged of any other offense, and the assumption that their flight risk has also not been proved. The issue of abordment alone cannot mean their flight risk, Your Honor. I end by saying, Your Honor, that you have been invited to a fishing expedition, which I pray that this honorable court does not entertain the circus that will, at the end of the day, prejudice the Kenyans right before you, whose only crime was to participate in a demonstration that the Constitution allows them. Thank you.
No, that will be all.
Yeah, just in a bit rejoinder to what my learned colleagues have stated before this honorable court. Your Honor, the state will simply say that our application is well grounded in law. It is said articles of the Constitution that have been enlisted in the said notice of motion, and the averments that have been stated by the investigating officer, DCI Inspector Bondo, who is in court today, and has adduced several reasons as to why the state is well grounded in law and merited in seeking the pre-charge detention orders, that is a period of 10 days, for the suspects herein to be housed at Kibi Police Station, for the investigations to be finalized due to the complexity of the matter, the compelling reasons that have been stated by the investigating officer, and several others that have been listed in the application that I'm sure the court will have an opportunity to read. And just to finish up, we shall simply draw the court's attention to the celebrated case of Oscar Sudi, where the tests to be applied in whether to grant orders of pretrial detention, what the court requires to look at, and considerations that are to be made. In this very celebrated case of Oscar Sudi, we also have the case of Michael Butich, where it was clearly stated what tests need to be applied. And that is that whatever application is brought to court seeking pretrial detention orders needs to be merited. We need to demonstrate that in granting those particular orders that the state or the court that grants the said order will balance the rights of the respondents hearing vis-a-vis the rights of the victims in whom we have the complaints that have been lodged at Juja Police Station, several other issues, the exhibits and the evidence that are to be adduced. And that is why we are in this court seeking orders 10 days. Upon the completion of 10 days or even before, the state will have collected all the evidence that is going to be relied upon. And I'm sure we are going to convince this honorable court, and we have convinced it through the same application that the application is well merited. And we are very and hopeful that the 10 days will be granted to the state. We shall supply the authorities that the state relies upon for the court's consideration. That is all.
no counsel.
Just
this is totally unrelated to that. We have had 3 children in the suspects. We just like to know if this court would perhaps give us directions on how.
The court will give you concrete and yes, general directions.
And the issue of the snacks, you can look at it, they're very hard.
The court
They're very
is
hard.
the head of the children's court. Are we together?
Thank you.
No,
I'm saying
this
the
court.
food.
No.
Yes, thank you.
That is not for the court, that is for you, and we take a recess.
Oh, very well.